Hello students and welcome back to bankexamstudy.com. My name is Ramandeep Singh and today we are going to do an important topic, that is Bankers Book Evidence Act 1891. Every year there is one or two questions from this particular topic in your IBPS RRB GBO Scale 2 and Scale 3 exams. And today we are going to cover it, right? It's a very short topic. We are going to cover this within 14 minutes. Right after this, we are going to provide you MCQs, right? So the MCQs are available on our dashboard for IBPS RRB Scale 2 2025 course is available on bankexamstudy.com, in which we are covering the entire syllabus. You'll be getting video classes, the notes, quizzes, MCQs, full length test series, and the power capsule. We are covering the entire syllabus. Link to join the course is available in the description. This is our WhatsApp number where you can contact us. And let's start the session. List of our successful students. All these students, they took our course in the 2023 and then in the 2024, and they cracked their respective exams and they got the job, right? So let's start the session. So the Bankers Book Evidence Act 1891, it was enacted to simplify the process of producing banking records in the courts, right? So in case there is a case at the judicial courts, at district high court or the Supreme Courts, in case banking records are required, how those banking records should be submitted at the court? That's what this Bankers Book Evidence Act, explains. So before this act, the banks were compelled to carry bulky ledgers and registers into court, which disrupted the banking operations and it exposed the confidential customer information. So what was the problem before this act? The problem was all the times they need to carry all the original data, right? So all the original database, original ledgers that needs to be carried to the courts, right? Then the second issue, the privacy of customers, Even if certified copies can be used, but the courts were asking the full-fledged ledgers and detailed records, right? And then the court was asking the original documents. And the banks, they were not having any copy, right? The banks were having copy of maybe Xerox copy of that. The banks were not having the original copy after submitting it to the courts, right? So original documents being submitted are to the courts, right? Being submitted. So these were some of the issues. So what are the solutions provided by this law? The first solution, certified copies. So now certified copies means the copies are signed by the branch manager or the authorized person. So that is acceptable by the courts, right? And generally the court may not ask the complete ledger. Certified copies are sufficient. So this is a solution provided, and original documents need not to be submitted. Certified copies needs to be submitted, right? So this is a solution provided by Bankers Book Evidence Act, right? So that's what it is. Let me just remove it. So the act allows certified copies of entries in the bankers' books to be admissible as evidence. So in case of a bank statement, so let's say bank statement of a customer. Now a bank statement signed by the branch manager, it is a certified copy and it is an admissible evidence, thus protecting both bank and the courts from inconvenience while maintaining the authenticity, right? So what are the objectives? To allow certified copies of entries in banker's book to be used as evidence. So if the branch manager signed a statement that is an evidence at the court, it protects the banks from losing the original documents or damaging the original records. To balance judicial requirement with confidentially, now the courts are happy and the bank is also happy, and to extend the scope of admissibility to electronic records. Nowadays, even the electronic records are also acceptable. The copies of electronic records are also acceptable as evidence. They can be certified and they are acceptable at the court. So as per the law, bank include any company or institution carrying the business of banking as per RBI Act. Banker books includes ledgers, day books, cash books, accounts books, and other books used in the ordinary course of business. And after the IT Act 2000, the printouts of digital data stored in the servers, in the databases, the copies of that database is also considered as banker's book. What do you mean by a certified copy? A copy of an entry in a banker's book that bears the certificate as prescribed by section 2 subsection 8. There are conditions. First of all, it should be an entry in the banker's book. So the data should be in the bank's database, right? And secondly, it bears a certificate. There should be a proper signature by the branch manager. So these conditions should be satisfied to consider a copy of the evidence as a certified copy. So the certificate must state that the copy is true copy of the entry in the bank's database. The copy is still in the possession of the bank. The bank is still possessing that data, and it must be signed and dated by the principal accountant or the branch manager. These are the three conditions that must be satisfied so that a copy can be of an evidence can be a certified copy. A certified copy would be considered as an evidence at courts. So a certified copy of any entry in the banker's book shall be received as prima facie evidence at legal proceedings. Prima facie evidence means it is accepted as true unless disproved, right? So it is acceptable. The bank is not required to produce the original book unless asked by the court. If the court finds it necessary, the court will ask the bank to produce the original records, and the bank is going to provide the original records. So for example, if a dispute arises over a check dishonor, the bank can produce a certified copy of account statement instead of the original ledger. So the conditions of admissibility under section 5, the book must be regularly kept in the course of business by the bank. The entry must have been made in usual and ordinary course of banking operations, and the bank must be under the control, under the custody. The book must be, it should be in the control of the bank, right? So the record should be in control of the bank, and this ensures the authenticity and reliability of the record. So the custody is important, and it should be in the ordinary course of the bank, and it should be regularly kept in the course of business, in the regular course of business. Restriction on production of original books. A bank cannot be compelled to produce its original books in the court. In the day-to-day operations, the bank should not be compelled, but the court may ask. There are exceptional cases. In the interest of justice, the court may ask the bank to produce the original copies. In case of fraudulent activities, the court may ask, right? To safeguard, this safeguards the confidentiality of the customers and smooth functioning of bank. Only in case of exceptional cases, the banks, they are required to produce the original banker books. Inspections of banker books. A party to a legal proceedings cannot demand inspection of banker's book unless the court permits it. Courts have discretion to allow inspection, but only circumstances where justice requires it. Only in case the justice require that the banker's book should be inspected, it should be checked, it should be produced in front of the court. Only then the banks are required to bring the original documents, original books to the court. Otherwise, certified copy is acceptable. This prevents unnecessary fishing into customers' accounts. Privilege of bankers. The banks generally enjoy protection from unnecessary disclosures. Confidentiality of customer data is preserved. However, in case of frauds, criminal breach of trust, or misappropriation, so these are exceptional cases. In these kind of exceptional cases, the court may ask the banks to produce their books to the court, right? As per the amendment, as per the IT Act 2000, the digital data, the digital books are also considered as bankers' books, right? So the printouts and electronic copies, if they are duly certified, they are admissible as evidence. Digital copies of the statements certified by the banks, signed by the bank manager, branch manager, signed and dated, they are considered as evidence. The certificate must confirm that the computer was functioning properly and the entry was made in the regular course of banking business. So the courts have repeatedly upheld the certified copies are admissible without production of originals. However, there are prima facie evidence, which means they can be challenged by the opposing parties. So in the past, we have seen various cases when the even the certified copies, they were modifications that the computer technology, the graphic design technologies are very advanced now. That is why the court may ask the bank for the original documents, right? So in a recovery suit filed by the bank, the court will accept certified account statement as evidence of debt, but the defendant may still contest them by cross-examining the certifying officer, right? So what is the importance of this act? It reduces the disruption of banking operations. In the past, the banks were spending a lot of time and energy, lot of resources in producing the original ledgers and original documents to the courts. But now certified copies are there, so which reduces which reduces the efforts that need to be spent on regular cases. It protects the bank from losing original books. Obviously, the banks, they keep original books with themselves and they provide certified copies to the court. In the past, they were providing original copies to the courts. It safeguards the confidentiality of customers' data. It safeguards the privacy of the customers' data, and it provides, after the IT Act 2000, there is a the electronic records are now recognized. It ensures smoother judicial proceedings in financial disputes. So what are the limitations? Certified copies are not conclusive proofs. They are only prima facie evidence, and opposing parties, they can demand further verification. The courts, they still have the power to order the banks to produce the original records. And the Act does not override the Evidence Act 1872, but it supplements it. And that's all for today, students. I hope you like today's session. Please go through the MCQs and also download the notes that I have provided. And if there is any doubt in your mind, always ask your doubts and I'm going to answer all your doubts. And that's all for today, students. Thank you and have a very nice day. Bye-bye.